Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will & Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, the flagship publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed some of the legal issues regarding wearable technology. This podcast will discuss some remedies for patent infringement. If a party is sued for patent infringement and a court ultimately determines that there was infringement, the next step in the litigation process is to determine the remedy to which the patent owner is entitled. The infringer provides the remedy that tries to make the patent owner whole or put the patent owner in a place that it would be if there weren't any infringement. Under the law, there are two broad categories of remedies. One category is called equitable. Equitable remedies are basically orders that the court issues. For example, a court might order that an infringer stop his infringing activity. Another example would be an order that mandates the destruction of infringing products. The other category of remedies is called legal. A legal remedy involves the payment of money, called damages, to the injured party, the patent owner in this example. Paying damages is a common outcome when a patent suit ends with a verdict of infringement. If damages are to be awarded, a central question is how much? That is, what's the proper size of the damage award? As you can imagine, this is usually an area of intense disagreement between the infringer and the patent owner. The U.S. patent laws set a minimum amount of damages by what's called a reasonable royalty. That's the royalty that would be paid on the sales of the infringing products. The procedure is to calculate a reasonable royalty, can be complex, and depends on several factors that a court described in a case about 45 years ago. A simple way to understand what a reasonable royalty is to think about what royalty the patent owner and infringer would have agreed upon if they had a good faith negotiation before the infringement began. A reasonable royalty might be a percentage of the selling price of the infringing product, or a fixed dollar amount for each sale of an infringing product. An alternative to damages based on a reasonable royalty is damages based on the patent owner's lost profits. This requires that the patent owner prove what profits it would have made if there wasn't any infringement. Establishing that proof can be difficult, although in 1978 a court gave some guidance on how to do so. When a patent owner pursues damages based on a reasonable royalty, or damages based on lost profits, the analysis is usually complicated. Attorneys typically retain expert witnesses who specialize in economics to help with the calculations. Each side in a patent lawsuit typically retains an expert, and the conclusions of the experts are usually contradictory. These different views are presented to the court when the experts submit their respective written reports and testify about those reports. The jury then weighs the differing evidence and decides on the final amount. The procedures for assessing a damages claim are generally well understood. However, in recent years, the courts have taken steps to limit the amount of damages by, among other things, constraining certain theories that experts use to justify their calculations. So, for example, if a patent owner proves that a product infringes his patent, his damages generally can't be based on the value of the entire product. This means that if the patent covers a small part or feature of the device, it is the value of that small part or feature that forms the baseline for the damages calculation. In other words, the amount of the damages must be commensurate with the value that the patent provided. If, for example, the patent contributed $1 of value to a $100 infringing item, the damages in most circumstances will be based on the $1 amount. The complexity of damages calculations has given rise to certain shortcuts or rules of thumb. Applying these rules has been one way to simplify the calculations. However, there is an inherent danger that these rules can become arbitrary because they aren't tied to the facts of a specific case. When that happens, damages can get detached from reality. This happened in 2011 when the so-called 25% rule of thumb was questioned. It was applied in a case involving a patent on software activation, and Microsoft was found to have infringed in order to pay $388 million in damages based on an expert's application of the 25% rule. The expert concluded that the 25% of the value of Windows and Office license keys multiplied by the number of keys sold was the proper measure of damages. The court ultimately disagreed, saying that the 25% rule was fundamentally flawed because it was untethered to the facts at issue. So this shortcut or rule of thumb is no more, and litigants must focus on the underlying principles when making their damages arguments. When faced with patent litigation, it is a good idea to assess the potential damages early on. If you are the patent owner, you can evaluate what you might recover if successful in the litigation. If you are the accused infringer, you can consider your potential exposure. Don't wait too long to do the assessment. Getting that done early will help guide litigation strategy. I hope that you found this podcast helpful. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@mwe.com. Thank you.